So at this point, Ms. Corey, this is really to check and see to make sure that you've been paid, you have contact information. Can you kind of give me an idea where you're at?
Sure. I have received intake packets from both parties, and Mr. has paid in full, and Ms. Despain is, we agreed to a payment plan. She has made 2 payments out of 3. I'm okay with that, and I have initial appointments scheduled with both of them this week. Okay. So everything on track.
All right, sounds good. Anything else you wanted to add, Ms. Corey?
No.
Okay. Ms. Bliss or Ms. Dowell?
Nothing for me, Judge.
Your Honor, I do have one thing. I have been having some problems communicating with the court by email. And I could be completely confused here today, but I believe we set something for a presentation of orders in this matter as well.
I don't have that on my docket at all.
All right, it looks like I'm thank God for my support staff. They're just informing me that's for next week.
Okay.
So it looks like we're good to go. Thank you.
All right, thank you.
Thank you.
I don't know if we have Ms. Fellows.
Yes, Your Honor.
Okay.
I am here.
Beth Fellows and Philip Jones. Philip Jones.
And I don't see him on the participants list.
I didn't see him either. This is a GAL compliance review, and it's very straightforward. So,
Well, at this point, Ms. Bliss, can you reach out to him and tell him that we're trying to get this matter taken care of?
Yes, Judge, and I'll just I'll turn my screen back on and wait for a break to interject and let you know when I've spoken with him.
All right, thank you. And Claremont matters. We have Miss Baldwin. We have Miss Holder. Do we have anyone else appearing? Excuse me. Okay, what's your name? Okay, Mr. Thompson is here in the courtroom, so I believe you are. Go ahead and just have a seat up at the table there right in front of the microphone. Be just a second. All right, so Ms. Baldwin, I'll turn this over to you and let you decide which matter you want to address first.
Thank you, Your Honor. Essentially, I would just kind of argue them sequentially together. This is really regarding a family unit in all reality. My client is the father of Sawyer, who's age 9, but he's also the father of Jacelyn, or Jace, who's age 13. Although he's not, he'll admit or acknowledge he's not Jacelyn's biological parent. He's been absolutely her functional parent in every way since she was 3 months old. This is a family unit that has existed together as a family essentially for more than a decade. And so as a result, my client has continued to raise Jacelyn, hold her out as his own. His family says that's our, his family and extended family say, hey, Jacelyn is our family. My client says this child is my family. This is my child. I have raised her. She's part of me. I'm absolutely her father. And no one really disputes that history, and it disputes anything associated with that. So when we look at that, it's really critical when we understand that these are incredibly bonded, incredibly together individuals. When we look at the time, even since separation that these individuals have spent, is again very bonded, very consistent. Since separation, this is a child that spent more than 50-50 time with my client. Both children at this point have spent more time with my client than with the mother. And that's even more true for Jacelyn, who will actively choose to not be in her mother's home and spend more time with my client, declining even more time with her mother, saying, I don't want to go there. I want to stay with my dad, who is my client. The only response that you have from Mr. Thompson, and I have it in my file, I'm not sure if you have it in yours, but the only response from him is essentially, yeah, maybe I want to be involved if that kid's really my kid, and demanding a DNA test. This is a 13-year-old child. He doesn't say, Mr. Thompson doesn't say he spent any time with this child, has any connection to this child, has engaged with this child in any way. It's just, and he fully acknowledges, hey, somebody told me this isn't my child, and I want a DNA test. So it's very clear that Mr. Thompson really is not that interested in being engaged, and really just wants to clarify whether or not this is his biological child. And if she's not, has no interest in her whatsoever. And that's not somebody who's raised a child and is engaged with a child for an extended period of time. There are major concerns regarding both the mother in this case, as well as Mr. Thompson. Mr. Thompson's concerns are largely just he's a non-entity. He has not been involved in Jacelyn's life historically ever, to the point where he's a functional stranger to this child. And should not have any visitation whatsoever with this child. And again, based on his response of not wanting to, if he's not biologically related, I think it's appropriate he not have any visitation with this child. In looking at the concerns regarding the mother, there are serious safety and security concerns really for both children. Those include both drugs and alcohol consumption. My client details significant concerns regarding alcohol consumption, but also marijuana consumption. The children come home smelling like marijuana, about the mother being out sort of all hours of the night, not coming home, leaving the children sort of to their own devices when they're in her care. We have a 9-year-old that, because again, Jacelyn spends more time with my client. So when the 9-year-old is supposed to be with mother, gets left home for extended periods of time, no phone, no way to call for help, no way to reach out to anyone else. So there's no way for him to even call 911 if there's a spot of trouble. And this is not an independent 9-year-old. This is a 9-year-old who has his own issues and his own troubles, and is a child who's getting in trouble at school. This is not a child that in any way should be left home alone, but he's left home alone from 8:30 in the morning until 4:30 in the afternoon. That's a very extended period of time for a child that age, and a child with really this limited capacity, and again, with no ability to call for help. When we're looking at the 13-year-old, it's clear that she is being parentified. She has fears of loss of her own education. Mother is currently—
Objection, Your Honor. The 13-year-old is not a part of the parenting plan issue.
Well, I'm arguing about both. So the 13-year-old.
So I addressed both when I called him.
So the 13-year-old has fears of being parentified, and mother's currently pregnant. 13-year-old has a fear of essentially loss of her own education, and being forced to nanny for her mother, because she's had that experience with Sawyer, with the 9-year-old. Essentially, she knows what it is to just be left and be expected to babysit, and not sort of the 5 minutes here, 10 minutes there, but just this extended periods of time where mother's just gone. And these are long periods of time. The living conditions in mother's home are reported to be horrendous by more than one person, including animals that were left uncaged. And these are not like dogs or cats, but other types of animals that belong in cages, and just left amongst the house with no one cleaning up after them, and just creating horrendous conditions within the house without anybody cleaning up. This would lead to the children then, when they would return to my client, they would obviously smell like they were in that household and in that environment. So we have the reports of what that was like, but also the impacts that still has on the kids today. Huge concerns about Jacelyn in this case, the 13-year-old. about mother essentially being spiteful and saying, I'm angry at you, and leaving her with random people. And that included, we believe, Mr. Thompson. So child doesn't know him, and mother, out of spite, takes her to Mr. Thompson, drops her off, and is essentially see you in a few days or see you never. Kid doesn't know who this person is. She's dropped off with a strange man and left there. So for this child, it's terror. She's been removed from her father and removed from her mother and left with this person who frankly says, if this isn't my child, I don't care. So again, this idea that we have somebody who should be a protective factor for a child just absolutely engaging in behavior is wildly dangerous to a 13-year-old girl. And again, this is a person who is not, we don't even know his connection to her. The 13-year-old's repeatedly placed in dangerous situations. We have the incident where essentially she's calling for help because she's in a situation where there's drunk driving. We have a situation where she's running from the mother's home because I would argue that there's domestic violence happening. They're beating on the door, trying to get in. Child eventually and runs away, and then is basically on the street without a phone and calls my client for help. My client comes and gets her, and then my client does the responsible thing, says, hey, I have her, she's safe. And mother then says, I demand, in this hot incident, I demand she come home. So again, child running in a very toxic situation. And again, we have repeated instances where not just she's reaching out to my client's significant other, grandparents on my client's side, saying, I need help. I need to get away from mother because the situation is so out of control in mother's household. So just a really chaotic situation in that household. Both of these children need education. They need security. They need parents who put them first. That only happens in my client's household. These are, again, concerns about mother and the people that she invites into the children's world. We have evidence that she brought into their world this individual who then is arrested for crimes that were committed. We have the children trying to hide things while these people are on probation, are very cognizant of some of these difficulties. That's not a place for 9 and 13-year-olds to be placed in, or not appropriate for them. So there's a lot of factors here, but it's very clear that my client is Jacelyn's parent for all purposes. This is a parent who has financially supported her. This is a parent that has functionally supported her, educationally goes to her parent-teacher conferences. He is the one, he's held her out as his child since she was 3 months old. He has continued to hold her out since they've separated. In every way, he has fulfilled the role as a parent for her, and has continued to do so despite the end of these parties' relationship. And this child clearly feels the same and has spent more time since separation with my client than with the mother. So at this point, we are asking the court to enter an order placing both children primarily with my client. We do propose some time with the mother that should come with some restrictions. So we are proposing visitation that occur on essentially alternating weekends from Friday to Saturday. There should be a requirement that the mother is required to take the children to their pre-scheduled activities. I know at least the youngest child has soccer. That's important to that child, that mother be required to transport to that activity. It's not for forever. It's just a couple week season. The court should appoint a guardian ad litem in both cases. It's reasonable if it's the same person in both cases. In the parenting plan case, I'd ask the court to just apportion that 50-50. In the de facto case, I would ask that be essentially 30% or 33% to each person. As far as Mr. Thompson's obligation, the court can inquire, and if he's obligated, if he has income, he can pay. If he doesn't, then perhaps that can be county pay. The court should award child support in both cases. We filed a child support worksheet that we've proposed in both cases, and backed that up with documentation to show that that is appropriate. But we do believe that this is reasonable. It's protective of the children in this case. And both children need that protection so that they can have normal, healthy lives.
So Ms. Holder, I'll get to you in just a minute. I want to ask, in regard to Mr. Thompson, Ms. Baldwin, I'm trying to figure out at this time, he's not been established to be the parent, correct?
We don't know. So he says that he's on the birth certificate, and so we're not sure. So we need to order the birth certificate to find out if he's currently on it. He says he is.
All right. So Ms. Holder, I'll get to you in a minute. I'm going to have talk to Mr. Thompson here for a minute. He's here in the courtroom. Mr. Thompson, do you believe you're on the birth certificate?
I signed it.
Okay.
I was there when she was born.
Okay. All right. I did not see any documents or anything from you in the court file. So can you tell me what's going on there?
I got handed all this 2 days, or on Saturday. I was supposed to have something in by Monday. I'm actually illiterate. All right. I don't read or write well at all. So I don't even know any of these paperworks, and I can't afford to pay for somebody to help me out with it.
Okay. So when are you saying you were served?
I was served the Saturday before the Monday that all the paperwork had to be in by.
Okay. Tell me, do you have a date? Are you talking about a week ago?
Hang on. I actually marked it in my calendar.
He submitted a response that's filed on August 28th.
On the Tuesday after,
Okay, just a second. Let me get back into,
I was served on the 24th of August
okay.
with paperwork saying I had to have something in by the 26th.
All right, so I have on August 28th, a response to the petition.
And the proof
Is
of
that the
service.
only thing that you have filed?
I only filed that one paper because I didn't know what else to file.
Okay. All right, Ms. Baldwin, have you received anything else?
No, and there is a proof of service filed August 13th that would indicate that he was served on August 12th.
Okay, just be quiet.
I had a bearded man show up on that Saturday. I marked it.
Okay, so let me ask this, and I'm not intending to embarrass you in any way. You say you're illiterate.
Yes.
Do you have any level of reading or writing?
Very little.
Do you know a grade level or at all?
Like third.
Okay. All right. So I have the limited information on the response that is in here. In regard to that response at this time, is there anything within that you want to point out to me, or?
I'm only here to say my piece because I had something to do with Jace. Not a lot. She came to my house during the summer, generally 2 weeks a year. And you would come up to my house sometime around Thanksgiving and stuff. She knows her family. She was babysat by my mother for most of her life. And 2 years ago, when they started divorcing, Kaya and Jace come up there, told me that she's having troubles. Her psychiatrist says that she needs to separate and figure her stuff out, and that she shouldn't be coming up there right now because she's confused. I said, all right, I love you, honey. I'm always here for you. And I didn't see her again until I got handed this paperwork.
Okay, I'm going to leave it at that because I need to go off of what was written and
All right.
filed. Okay, I understand what you're saying and where you're at. All right, so I'm going to hear from Ms. Holder now in regard to the parenting part of this. Ms. Holder?
Yes, Your Honor. I didn't want to be rude, but I was asking for a 2-week continuance as I have not filed responsive pleadings in this matter. I was retained on the 26th. My pleadings would have been due on the 27th. Court made it abundantly clear last week while I was in a hearing that it's cracking down on late filings and late pleadings. I attempted to work out something with Ms. Baldwin. She gave me an extended deadline to get paperwork to her on Sunday, 9/1. After digging into this case and finding a lot of evidence that is important for the court to hear, filing last week was not going to happen. So I am asking for a continuance for 2 weeks in this matter. Also, regarding the parentage situation with Mr. Thompson being there, hearing conflicting things from Ms. Baldwin and from Mr. Thompson. Ms. Baldwin saying that the child in question doesn't know who this person is. He's a strange man. You just heard from him that she used to spend 2 weeks every summer with him. So clearly she does know who Mr. Thompson is. As far as if I have to go on the argument for the case, this case was originally started back in 2023 with a proposed parenting plan where Mr. Marvell did not fill out any information in 3A or 3B factors, now claiming abandonment that was not originally pled, now claiming substance abuse issues that was not originally pled. Without getting into too many details, because I've not filed any pleadings yet, Mr. Marvel's current partner and he were together. They then broke up due to DV allegations against Mr. Marvel.
Well, again, nothing's filed. And so this is just.
Okay. Here's I'm going to ask a couple questions here. So first off, where are the children now? Are they with mom?
I believe they're with my clients, but I can confirm. Let me have my staff.
That is incorrect. They are with me currently. Kaya Claremont, they're with me.
Okay. All right. So here's what I'm going to do. I understand, there are rules, there are deadlines, and you're right. I'm adamant about these late filings, and I appreciate that I did not. I can actually prepare my cases, know what I have, and not wonder whether something new has been added and I haven't seen it. I want to do what's in the best interest of these children. It is not in the best interest of the parents. That's not the law. It's of the children. So at this point, I am going to be continuing the matter. The question is whether or not, I guess my question is at this point, what to do in the meantime. Sounds like they are both with mom. And Ms. Baldwin, has your client been receiving visitation, or what exactly has the status been?
So historically, these parties have been 50-50, but then sometimes the children stay with my client longer. So they'll alternate 4 days on, 4 days off. But then there are periods where, especially Jace just stays with my client for a couple weeks at a time because she doesn't want to do the exchange. So that's what they have historically done. If the court is going to continue the case, and at this point, this was sent and served about a month ago. So that's always challenging. My client took the day off of work. For him, he's out about $500 for not working today. And attorney fees for a motion that's now going to have to be argued twice, which the court should consider when we're a month in. So I appreciate sort of the timeliness argument, but also my clients waited a month to have this heard. So what I would ask the court to do is, again, there are serious concerns about the safety in mother's home. The court should order that there's to be no use of alcohol, there's to be no use of marijuana, there's to be no use of any mind-altering substances in the mother's home whatsoever. There's to be mothers not to give her time to anyone else. Children are not to be left unsupervised by anyone, and that both children have to go to school on time every day, and they can't be out and about later than 9 o'clock, because that's one of our concerns, is that the children are sort of drug out of town up until like midnight, 1 o'clock in the morning, and then they have to go to school the next day, which is a significant impact on them. The court should also, I would propose that the children be primarily with my client, and then the court awards some amount of time to the mother, but the court can do as it likes. The court should appoint a guardian ad litem today. There's no reason to delay that in either case, because the court's going to do that no matter what. So there's no reason to delay that. And the court should order that children are to be transported to their regularly occurring activities, things like soccer, because again, those are for them, not for the parents. So the idea that parents sort of use that as a lever against each other and thereby deny children the things that they enjoy isn't appropriate.
Ms. Holder, anything else?
I agree with Ms. Baldwin that appointing a GAL would be appropriate. We were going to be asking for one, as there was no motion in the current pleadings before you. And then as far as who should have custody of the children, these parties have been operating for the last year and a half with the status quo without a parenting plan actually in place. Everything's been proposal. I say that it remained the status quo. I understand that there are grave concerns for the children, but that goes two ways. My client also has grave concerns. They just have not been addressed yet.
So, Mr. Thompson, I don't want to make you feel like you're being left out of the loop in this. It's trying to figure out where you fit in at this point, because I have very little information, and that's the problem at this time. So let's first appoint a guardian ad litem. Let me see what the next three are.
The next three names are Keith Lawrence, Ann Height, and Karen Lawrence.
Ms. Baldwin?
I'll strike Ms. Height.
Okay. Ms. Holder?
No strikes for me, Your Honor. I'm fine with Mr. Lawrence.
That's fine.
So, Mr. Thompson, you have a right to strike one of these names if you...
I have no clue who they are. So.
Okay, so I will go ahead and appoint Keith Lawrence. You know what a guardian ad litem is?
Kind of.
Okay, so they do an investigation into the case and make a recommendation in regard to the children. Okay, all right. Keith Lawrence, are you still on here by chance?
I don't see him.
Okay. So here's what I'm going to do for now. Again, this is difficult because the court has limited information. The children, I guess my other question is, how far apart living wise are the mother, and I'm just going to refer to them as mother and father. It's not to discount you, Mr. Thompson. How far apart do they live? Are they in the same school district?
I believe Mr. Thompson lives quite a ways away.
I live an hour away.
And
Okay.
then the other two
I
parties
thought-
are both in Longview. So no, they're not far.
Okay. All right. So what I'm going to do is, for this next week, let's see, we're on Tuesday, that the children will remain with mom for the rest of this week. And then come Sunday at 3 p.m., the two children will be transferred to Mr. Marvel. So I'm basically doing a 7 on, 7 off between those two parents. In exchange on Sunday afternoon, 3 p.m. I'm assuming you can work out where that exchange is.
Let's just say Fred Meyer Garden Department in that parking lot.
Does that
Why
work for your-
can't we do the
Ms.
house?
Claremont, be quiet. Ms. Holder?
I am unsure of where historically the exchanges have been happening. I would like for the stability of the children just to keep things as they are during the interim process. So if the court would like to hear from my client about what has historically would have been done, I think that would be appropriate.
Fine. Here's what I'm going to do. I don't want to start involving the parents in court process. So they have attorneys. I expect the attorneys to be able to speak for them. So what I'm going to do is 3 o'clock. It will be at the garden department unless otherwise agreed upon between the parties. If they can agree on something different, I'm fine with that. Neither party, nobody is to consume any alcohol 12 hours before or during the time that they have the children. Same with marijuana and non-prescribed drugs. Neither party. Neither party is to leave the children unattended. The children are to be in school on time and not miss any days unless they have a doctor's note. The children are to be taken to all their scheduled activities and appointments. Now, Ms. Holder, do you have any information in relation to Mr. Thompson and your client as far as what they have done in the past as far as visits with the one child?
My understanding, Your Honor, is that as far as Mr. Thompson goes, he was getting a week or 2 weeks during the summer, and that happened up until about 2 years ago, which is the point in time that these parties split up. So once these parties split, Mr. Thompson was really no longer in the picture. I believe that Mr. Thompson is still free to see the children if he wants, especially Jace, but I do not believe he has had much contact in the last 2 years.
Okay. All right. Have you had contact in the last 2 years?
I have messaged her on birthdays and holidays. I can only get a hold of her mom. Her mom tells me she'll pass it along for me.
Okay.
I've seen her last Sunday, and her and I were talking about visitations of me seeing her again.
Okay. So here's what I'm going to do because I have limited information at this time is I'm going to have Zoom or whatever platform for Mr. Thompson to see, I'll just call her Jace. That seems to be what she's called. Jace, one time per week. Are you working? What days do you work?
I'm always on call, but I work 5 days a week, sometimes 6. But I'm always there. I'm always at work. So I'm able to do anything I pretty much need to do.
Okay, so would a Saturday work?
Yeah.
Okay, so the Saturdays that the mom has Jace will have Zoom or whatever platform visitations for an hour from 4 to 5 p.m. Does that work? Okay, all right. And then as we move forward, we'll look at some other ideas, but that's what it's going to be for now. Okay.
All right.
All right.
I'm not too.
All right. So this is how it's going to be. I understand, Ms. Holder, you haven't had a time to respond, but at the same time, I'm going to set this over to October 15 at 9 a.m. I am going to grant $500 in terms for the fact that response was not done timely. That will be paid in 30 days. That will be by Ms. Holder's client to Ms. Baldwin. And then what I'm hoping is that Mr. Lawrence can get involved right away and maybe have some input on the 15th.
Does the court want to adopt for payment of Mr. Lawrence? Do you want to adopt sort of my proposal? And since it sounds like Mr. Thompson is
Yes.
looking, okay, I'll just portion. Okay, very good.
Okay, proportions is child support. Yes, Mr. Thompson.
I've been paying child support the whole time.
Okay, this is about the guardian ad litem.
Okay, I was just
Yeah.
making sure you know.
Yeah, I'm not addressing child support today.
All right.
I don't have enough information. I'm not addressing any of the other possible issues at this time. This is just to get us through until October 15.
And then can I have a drop dead date by which whatever they want to file is filed so that then we can respond prior to that October 15th date?
Ms. Holder, do you think you can get something by October 1?
Yes, Your Honor.
Okay. All right. So, Mr. Thompson, here's what, are you with Mr. Thompson?
Yes.
Okay. I want to make sure this gets written down is why I'm asking.
That's what I was trying to.
Okay. So, Mr. Thompson, there is on Monday a free clinic. I know you work and that makes it difficult. It is here at the courthouse. What time is that clinic at?
12.
From 12 to 2. Okay. It'll give you an opportunity to talk to an attorney and get some advice as to what you can or can't do. Okay.
Thank you.
Because of your potential for not being able to read or understand the legal papers, it is possible it's an ADA issue. And you can say that, ADA. I think she's getting it down when you talk to them. Okay. All right. I don't know. I don't have enough information to know. But
What is an ADA issue?
it's a disability, American Disabilities Act. I've been made aware of it, just pointing it out. I don't know whether it is or isn't. I'll leave that up to you to discuss with the attorney.
All right. Thank you.
Okay.
Then finally, can we put it on for next week for presentation? I just want to make sure that we get all the guardian ad items
That's
orders
fine.
entered, just to make sure that we're not delaying him any.
So Ms. Baldwin will go ahead and prepare papers to reflect my ruling today. And she will send those out for you to look at. If you agree that it reflects my ruling, what I decided, then you can just approve to have your signature and you won't need to be here next Tuesday. Okay. If you,
Get those out.
Ms. Baldwin will make contact with you.
Yeah, does he have a, let me see, he does have a phone number. I don't know if there's I'll call him and see if there's an email address. I understand that it's a little challenging with the literacy issue though. So we'll see what we can do.
Okay. All right. All right. So Ms. Baldwin will reach out to you to see if you have an email address that she can send the papers to take a look at. Okay.
Yep.
All right. All right. Is there anything else for today?
I don't
This
believe so.
matter is on for
No, Your Honor.
presentation of order.
That's it.
I did not see any objections per court rules. So Ms. Holder,
Yes, Your Honor. I don't have any objections, and I'm fine if you want to put appeared by Zoom in my signature line. I did have a question about clarification on the psychological evaluation that my client was ordered to have. She did call several providers, including the provider that father went to in this matter. Ms. Baldwin's client, Ms. Baldwin recommended and the court adopted her recommendation that my client receive a PhD level psychological evaluation, the same as father, so that there would be some apples to apples. When my client called around, one of the providers that she called was the same provider that father went to for his evaluation to see if that provider was available. That provider indicated that it does mental health evaluations, but not psychological evaluations. So that kind of raises the issue of, in the GAL report or the court investigator report, very clear that a psychological evaluation was done. So I just needed some clarification that if mother goes to the same provider that father does and gets the same evaluation that father did, that would suffice.
I have no objection. If it
Okay.
apples to apples.
Yeah, that sounds appropriate.
Okay, thank you.
All right, I'll go ahead and sign off on the order. Okay, and we have Ann Height, we have Ms. Gilmore. Do we have Aaron Anderson?
Yep, I'm hearing
Yes.
on.
Okay. All right, so at least yesterday when I was looking, I did not see the guardian ad litem report. Or I did see the guardian ad litem report that's filed September 10 is what it showed, but it wasn't showing yet in Odyssey. So I've not had an opportunity to review. And then I see July 24. Let me try to get back to what I was looking at yesterday. I do have a guardian ad litem report. So let me go back and see what I was looking at yesterday. Oh, it said canceled, so I'm not sure what's going on. It says September 10, guard item report and recommendations, and then Ms. Height, can you help me out here? I'm not quite sure what I'm looking at.
Your Honor, I filed my report July 24th, and I believe we are here today to review that.
Okay.
There has been some indication at some point along the way that Ms. Nelson might want to file some kind of response, and I did have a conversation with her, but when I looked last night and this morning, I didn't see anything filed. So, and just for as long as I've got your ear here for a moment, there is in my report on page 4, I mentioned that the child is in 6th grade. I was in error. She is in 7th grade at Cascade. So just a little detail there.
All right, thank you. All right, so I understand that the report has been filed, and I am one that requires a motion if there's any intent to change anything. So we do have the recommendations. I'll turn to Ms. Gilmore. Anything?
I apologize, Your Honor. I missed the first half of the hearing. I'm sorry, I've been jumping between with Kayak and Cowlitz. My client, we would like to respond, and I was assuming that the court would need a motion in this case. So I would defer to Mr. Anderson if he wants to do so, and then my client does have some concerns with the report. So we would ask the court to strike today's hearing.
So I won't be striking it, that it's here to make sure that the final report's been filed. So it's been filed and recommendations have been made, but I rely on a motion to be brought if there's an intent to request anything as far as wanting to have the recommendations followed. And at this point, I don't have such a motion. It gives everybody an opportunity to file anything that they want to address any concerns or issues that they may have with the report. Okay, all right.
Understood.
So it's been filed. It's at this point, and I'll leave it to the parties if they want to bring a motion.
Okay.
Okay.
Thank you, Your Honor.
Thank you. All right. Again, I see that the report by Ms. Schaefer was filed on September 3. Did the parties receive that?
Yes,
I
Your
did.
Honor.
Okay. And with that, anything at this time?
And I would have to defer to the court. I wasn't of counsel at that time. It was my understanding from a review of the record that the court was reserving on my client's motion. So we were before the court in May. The court then appointed. If the court wants me to file a motion, I understand. But it was my understanding that the court was basically reserving for the report. So we would be asking the court to adopt the recommendations at this point. But again, I understand the court's position regarding motions.
Ms. Jocelyn?
Your Honor, I don't think we need to jump through the hoops of a motion if I can just be heard for a few minutes. I think
Okay.
it's just moving it forward. Yes, opposing counsel was not present. Last time we were present in court, you had set over the hearing so Your Honor and Mr. Williams could review the letter from Desiree Mansauer, Silas's therapist, and also to get information from Ms. Schaefer. And then you were going to decide that said potentially we may need a full GAL or not, but I want to see the letter. I want to see Ms. Schaefer's report. My client, it doesn't appear that in the report she addressed like him not doing his DV sessions and Silas's therapist letter, but in lieu of that, my client's in agreement to the recommendations with a few slight changes, because I think the way that Ms. Schaefer phrases the different phrases, there is a safety net there. And so her requested, any requested changes is we're fine on the part with them communicating, them in family counseling and everything like that. We will just need to amend the protection order to state that they can be together, whether it's Zoom or not. Regarding the mental health evaluation, this is an issue that has already been litigated and brought up. Mr. Williams brought this issue up via his declaration January 27th, 2023. And just for a quick history, because it's been mostly with Judge Evans, my client filed the hearing petition 12/29/22. He brought up the issue of the therapy or the eval at that time. We had a hearing on September 14th. Mr. Williams had counsel at that time. He had counsel when he had the response. We did argument, the same argument I'm going to make now in front of Judge Evans, and he agreed he didn't order it. They're talking about an agreed order that was put in place prior to their final dissolution orders being entered. The parties then negotiated final dissolution orders, decided not to include the mental health evaluation. They didn't include it on the final parenting plan or any final order. So they opted not to include that. So that's already been taken care of. When they brought up the issue again, February 14th, 2023, Judge Evans agreed with that. He didn't order the eval. If you also look in the temporary orders that came out of that hearing, which would be the temporary plan 2/28/23 and the parenting plan 3/1/23, it's agreed there's nothing on there that states the eval. I was counsel, Mr. Williams had counsel. It was all agreed. We had a lengthy entry of orders hearing. It wasn't included. So despite that, if he really wants one, my client's fine as long as he pays. Otherwise, this issue's already been done and dealt with. So 1, we're fine. 2, no. 3, we're fine with recommendation 3. 4, we just want to clarify that The 30 days starts after they've actually set up the family counseling session, how Ms. Schaefer says, have it set up, have the first appointment completed. There's been some confusion with Mr. Williams in this case. And I think all parties, when that step starts after the 30 days starts after this first session. And then we're fine with section, after 90 days. My client would just propose, since these parties do not communicate due to a DVPO, that we just simply go to an every other weekend so it's easier to figure out who's who. And we just want clarification that the 90 days starts after clarification of the 30. We're fine with 6. And then also regarding the schedule of which games, who attends who, my client would be in further agreement to amend the protection order to say that he has to stay so far away at games so both of them can attend games at the same time, as opposed to alternating, which was a great suggestion by Ms. Schaefer. But if we want to amend the DVPO for the football games and say they just have to be 250 feet apart, that way it allows both parties. And that would be the only minor changes she would want.
Ms. Gilmore?
And Your Honor, just procedurally, again, I wasn't counsel at this time, but I would submit to the court that an order is an order. And so if an order is requiring in 2019 that she engage in a mental health evaluation, that is still an order of the court despite finalizing the case and not referencing it again because it was already in order. I think more importantly, we need to look at what's happening in 2024. The court investigator has concerns about mother's mental health because of her involving the child in conflict, her unilaterally terminating visitation despite
Your
the
Honor,
court's
we're going to object. This is not in declaration if she wants to argue this, and at this point she should put a motion forward.
That was contained in my client's declaration in the motion in May, and it's contained within the court investigator's report.
Yeah.
And this
Right.
issue's been decided upon already.
All right. I understand, Ms. Jocelyn. Go ahead, Ms. Gilmore.
Again, the evaluator has concerns. She needs to engage in mental health evaluation. I have nothing before me that submits that she can't provide financial. A lot of times that can happen through a health insurance provider. And I think it's really important in this case, again, because there is abusive use of conflict. We would object to changing from the 1st, 3rd, and the 5th. It's important that my client have additional time, especially since the court is currently, or the investigator is currently recommending 1 overnight. My client does agree to the recommendations. I think that's important to acknowledge. My main concern with this 30-day extension is that it's going to be vital that we start this counseling as soon as possible. Mother has a history of causing delay after delay, resulting in my client not ever getting visitation. So I think within the next 14 days, we need to agree to a family counselor. And at that point, yes, then we can go with the recommendations. I just don't want to cause any further delay. This child deserves a relationship with his father, and he was having a relationship prior to the retaliation that was resulted by mother on the motion. The notes from my client's visitation show that they have an extremely close relationship, and this abusive use of conflict cannot continue moving forward.
And Your Honor, we
Go ahead. Oops, you froze.
is all resulting from dad choking out the child in a DVPO. And so I think Ms. Gilmore and I are saying the same thing. I just want the 30 days to start after the family counseling. That may not happen in 14 days because they're going to need to address the issue of getting the orders to amend the DVPO. If it can happen, great. If it can't, we just need to do it as soon as possible. And if she thinks my client's delaying, she can bring a motion.
Ms. Schaefer, anything you wanted to add at this point?
I did want to address the clarification. I would like for everything to be in place before that 30-day calendar clock starts. I want there to be the meeting with all parties and the counselor, whichever route they decide to go, and make sure that that counselor understands kind of their oversight in their role and can agree to that, so that safety net is there for the child.
So that this is a little clearer for council overall, that when looking at the reports that I request from Ms. Schaefer or sometimes from guardian ad litems, is that this is close in time to a motion. And I think Ms. Jocelyn said it. I think it was Ms. Jocelyn, I apologize. That actually, I think it was Ms. Gilmore. Anyhow, that it's connected to a motion that had been brought. And This was just to have a quick look at things. So that's why I look at these differently and don't necessarily always require a motion. So that's why I'm going to go ahead and go forward on this. In regard to the recommendations, the court will be adopting with some clarifications, reunification or family counseling established for dad, Silas, and mom to help facilitate the following phases. Mental health evaluation for mom that was court ordered in 2019 to be completed. In regard to that, the court would like to just have an updated mental health. So that's why I'm asking, and I shouldn't say updated in the sense that I'd like a current mental health evaluation. So I would like to go ahead and have that of mom. In regard to the visits up to 4 hours unsupervised in the community until an intake for reunification or family counselor can be completed, a counseling plan established to facilitate and first appointment completed. Mom, dad, and child are expected to participate. Dad's wife, Jessica, can participate at counselor's request for parenting issues that may occur in dad's family home. I think that is appropriate, and the court will adopt that. After counseling is established, visits may occur at dad's home after 30 days of no issues arising. I agree, this needs to be after it's established, not 30 days from today, 30 days from the time that the counseling has been established. And that's where the clock is going to start on these other parts. And so after 90 days of established counseling and no concerns noted, visits may occur overnight from Friday after school or 6 p.m. if no school till 6 p.m. the following Saturday. They can occur every first, third, and fifth weekend. I go with first, third, and fifth, especially in a case where there have been the issues that have occurred here. That way, if there's any issue at some time that, hey, it's my weekend, she's denying the weekend, you can look at a calendar and know exactly what weekend you're on. And the first, third, and fifth will be dictated by the Friday of the month. And then individual counseling for child continues at his preference. And then schedule of who attends which games to support Silas if both are not able to attend due to no contact order. It sounds like, Ms. Jocelyn, maybe I misheard this, but the DVPO can be correct or not corrected, amended to allow that, correct?
Yes, Your Honor, she'd be willing to amend it to allow, like, say, a 250 feet, the football game, so both can attend.
Okay, all right. And I think that would be best for Silas. I'd like to see that.
Your Honor, I have a few questions, if I may.
Go ahead.
I'm assuming that the investigator is recommending 4 hours once a week, unsupervised until.
I'm sorry, say that again.
Unsupervised visitation 4 hours once a week. I just wanted to clarify that. That wasn't necessarily clear. I'm assuming that was the recommendation.
It would be, Ms. Jocelyn, would you agree once a week?
Yeah, it's once a week. It says up to 4 hours. So I think what the parties have been doing is sometimes it's a Saturday, sometimes it's a weekday after school. So weekday after school may not. I don't know if Ms. Schaefer has a preference if the parties can't agree.
I didn't have a preference. I wasn't sure with the football schedule and football practice and games, how that would work. So I didn't want to tie the parent into a specific day. That's all.
Okay.
But yes,
I can coordinate with counsel. No problem. I can coordinate with counsel. I feel like we can come to an agreement on days once I review the schedule. I just want to confirm with the court that the unsupervised visitation will be happening this week or in the next 7 days.
It's my understanding, Your Honor. I think we'd be in agreement with that because it's pending getting it all set up. So counsel just wants to send proposals.
Perfect. Is the court requiring input on the mental health evaluation for mothers? Input of my client.
I'm sorry, say again.
Is there the court requiring input of my client for the mental health evaluation?
Yes, I always like to have the other party have input.
Okay. And then I just lastly want to clarify that you're reserving on future visitation, like holidays and a more set schedule. This is interim.
Correct.
Okay, understood. Thank you.
Okay. Anything else, Ms. Jocelyn? Anything else?
No, Your Honor.
Okay. Do we want a presentation date?
Yes, please.
Okay, that would be September 24.
That works.
September 24. Yeah, if there's any way we could be heard earlier in the docket, it can do that. Like first couple.
We just had some complications today of people going to a kayakum and that, so I usually do. It just depends on what
Okay.
else is going on.
Oh, no, I understand. Miss Gilmore had a crazy schedule, so we can do the 24th.
Thank
Okay.
you.
Okay. All right, that's it for that matter.
Thank you, Your Honor.
08. Thank you. So, Ms. Fellows, can you kind of bring us up to speed in regard to being paid, contact made, any issues?
I made contact with both sides and I met with the mother last week and she paid in. I am meeting with the father in about an hour at 11:30 today. So far so good. We're moving forward.
Okay. All right. That's essentially what we needed to do today. Mr. Jones, anything from you?
Nothing's on the docket today, but I think we're having a little issue with the restraining order and getting my client being able to pick the kids up from school. But I think Ms. Bliss and I can figure that out now that I have some more information, but just so you're aware.
All right.
Thank you.
Ms. Bliss?
Nothing else from me, Judge. Thank you.
Okay. All right. That takes care of that matter.
Thank you, Your Honor.
Thank you, everyone. My apologies.
All right.
Judge, we set that over at the beginning of the docket. We set that over 1 week.
Oh, okay. Sorry.
That's okay.
We had another matter that I thought.
That was all for me. We called the Brodarius matter. That was the only other matter I had on, and we called that early in the docket as well.
Okay. All right. Is there anything else that anybody thought was on? All right. Hearing no one, that concludes this docket.